Good evening, this is video 4 of our series on this paper, Community Justice Model for Otara, Therapeutic Jurisprudence in Action, the case for a community court in Otara, written by Karen Harding, lawyer, on the 10th of December 2011. And we're now talking about Chapter 2, the state of the New Zealand justice system, as it was then when I wrote my paper. The justice system is of huge significance to society. Not only is it the place that resolves society's disputes and deal with those who breach our laws, it impacts on the lives of those people who appear in the courts, their families, victims and the community. It has a significant impact on our economy and on the taxpayer who funds the system. Court caseloads are increasing and daily criminal court lists have become overloaded. The system is under stress. There is criticism the system has become McJustice, you like McDonald's, McJustice, impersonal and with an assembly line quality. At the time of this research paper, the New Zealand government was spending $3 billion a year on the justice system. That included around $1 billion each on the police and the courts, and about $1.36 billion on the Department of Corrections for the 2011-2012 period. The annual cost of keeping someone in prison was at that time around $90,936 per year. It's obviously increased since then. In 2011 and 2012, $761 million was budgeted for that year to keep prison and remand prisoners behind bars, which was 55% of the corrections budget. That's our prison department. Only 12% of that budget was spent on the provision of education, employment, rehabilitation programs, psychological services and reintegration programs. By 2013, the Department of Corrections was expected to grow to become New Zealand's largest government department, bigger than the Departments of Inland Revenue and Social Development. The Corrections budget for 2009 and 2010 for the operating expenses alone was $1.1 billion, with $713 million of that to just fund the custody of prisoners. The legal aid budget makes up 2.5% of the New Zealand government's expenditure on law of order, so it's quite small in comparison. At the time I was writing this research paper, the Minister of Justice, the Honourable Simon Power, stated that the legal aid system had become unsustainable, and the current expenditure for the period of 2009-2010 was $172 million, and it was an increase of 55%. And they were expecting a budget blowout of $402 million over the next 5 years, and so they, as the government, were looking to cut costs. So reflecting on that, I went on to consider what's going on underneath this system. So recidivism impacts on the legal aid system, which has a high number of repeat clients, many of who can only be described as difficult, who account for around 63% of the legal aid expenditure. To save legal aid costs, the government cut or slashed rather funding to the community law centres, and that resulted in reduced access to justice, more self-represented litigants, and put more pressure on the courts. And the government started to roll out nationally a public defence service as part of its cost-saving solution. That's basically having in-house salaried lawyers working for the department, the Ministry of Justice. Dame Margaret Baisley, who did a report, who I've referred to as the Baisley Report, she reviewed what she called the hornet's nest that is legal aid in the legal aid system, and she observed that the process of criminal defendants being processed through the district courts in Auckland. She reported that the treatment of defendants during their court appearance in the court lists horrified and appalled her. Dame Beasley noted that while they were in the docks, the presiding judge would seldom look or engage with a defendant. Judges and counsel engaged with each other in a legal shorthand unintelligible to others, resulting in many defendants leaving the court confused, which is standard operating procedure in the courthouses in New Zealand, I must say. Subsection Chapter B, heading Underlying Social Problems that Impact on the Justice Sector. A great many individuals appearing in the criminal courts are inarticulate, they're illiterate, and they do not have English as a first language. The majority are beneficiaries, and they may come from socially deprived homes. Defendants are usually accompanied by their family. The Baisley report concluded that our courts, these are our New Zealand courts, demonstrated, quotation marks, lack of concerned support for people's social well-being at their most vulnerable time, close quotation marks. This is a result of a court culture that focus on the perpetrator, keen to process cases through a fast pace in an effort to cope with large work volumes, in a manner which ignores the practical needs of defendants who are also human beings with family and work commitments, and many of whom who have other met social needs. It is a system that ignores families. So what she's saying is our court system ignores the needs of families. Yet everyone's from a family. Many of the individuals appearing at court are from the most deprived homes in our country. Subchapter 1. The impact of substance abuse on the justice system. In New Zealand, 4.7% of the population have significant mental health disorders, including addictions. Serious alcohol, drug misuse and addictions have been found to affect 3.5% of the population. This affects around 150,000 people per year. For youth aged 16 to 25, this problem increases to 9.6%. Although substance abuse disorders are easy for professionals to diagnose and are amenable to treatment, uptake is slow. Just 34,000 people receive some form of treatment. And the reference is to a footnote here. Addiction treatment is everybody's business. Where to from here? National Committee of Addiction Treatment New Zealand, 2011, at page 2 and page 5. The government inadequately funds addiction treatment services. A report in 2011 by the Mental Health Commissioner found that 1.9% of the population, being around 50,000 people between the ages of 16 and 64 years, wanted help to reduce their alcohol and drug use, but didn't receive any assistance. Drug and alcohol misuse contributes to all types of offending, including driving offences, property-related offences, sexual and violent offences. The majority of crime, around 80%, is committed under the influence of alcohol and or other illegal drugs. In 7 out of 10 arrests in 2007, offenders were under the influence of drugs in the period leading up to their arrest, and 2/3 of our prisoners have ongoing problems with alcohol and drugs. Subsection C. Chapter, the problem of recidivism. The system, and we're talking about the justice system, has developed what we call, quotation marks, a revolving door phenomena of repeat offenders, close quote, who recycle through the justice system with no resolution of the underlying problems that trigger their offending. This has led to an overall increase in the age of sentenced prisoners and attributed to prisoners serving longer sentences because recidivist offenders circulate in our system for longer. Of those serving prison terms, 80% will serve less than 6 months and will have little or no access to rehabilitation programs in prison. The re-imprisonment rate for first-time prisoners within 48 months of release is 30% and 60% for recidivists. The reconviction rate is higher for Maori offenders at 80% within 48 months of release, with 62% of those being re-imprisoned. Subchapter, high rates of imprisonment. We have here in New Zealand the second highest rate of imprisonment out of 29 Western countries, higher than countries with high rates of violent crime. This rate of imprisonment of 203 individuals per 100,000 of total population has significant impact on Maori, who are disproportionately overrepresented in the imprisonment statistics. 51% of the prison population is Maori. The demand for containment in prison is effectively attributed to the structure of the New Zealand criminal justice system. There is structural discrimination against Maori, who are 7 times more likely to be sent to prison, a prejudice normalised through the high rate of Maori recidivism. Subchapter: Prison Capacity Crisis. Between 1995 and 2010, there has been a 68% increase in our prison population. By 210, our prisons reached a capacity crisis, the likes of which we had not seen before. Prime Minister John Key stated that he supported initiatives to cater for prison growth under National's hardline policies. However, the reality is we can't afford to build more prisons. The Minister of Corrections was at the time of writing this report with Judith Collins. Her solution for containing more prisoners was double bunking the prisoners in their cells and to store them in shipping containers. That's because we opened a shipping container prison unit in prison. This means that low-risk offenders and low-risk prisoners were being incarcerated in prisons such as Remataka Prison, in prison units made up of shipping containers, which were facilities providing little rehabilitation. This was to save on penal construction costs that the country couldn't afford. This was an initiative announced by Judith Collins as representing new thinking at corrections. By 2013, the Department of Corrections is expected to grow to become New Zealand's largest government department, bigger than the Departments of Inland Revenue and Social Development. The government wants to clamp down on youth crime, spending $47 million to construct a 30-bed youth prison that opened in July 2010 that will cost at least $7.3 million a year to operate. Former Youth Court Judge Carolyn Henwood expressed concern about this, stating, quotation marks, "Such institutions have never shown to prevent reoffending," end quote. Data from the Department of Corrections reveals those who start offending as teenagers are more likely to go on to become persistent offenders. Judge Henwood's experience in dealing with youth offenders, including the handful of offenders who commit the most serious of crimes, was that what was really needed, was close individual care. Dame Anne Owens, the former Chief Inspector of Prisons in Britain from 2001 to 2010, from her experience, formed the view that systemic changes are needed to reform the justice system, particularly for offenders aged 18 to 24 years who have high rates of reoffending, in order to transition them into adulthood and move them away from a life of crime. And that was Chapter 2. This was Karen Harding, barrister and solicitor, Auckland, New Zealand.